Good morning and welcome to the third session of the Innovator Training Scheme webinar series. My name is Colette Inkson. I'm the Innovation and Partnerships Manager for the Manchester BRC, and I've been working with Translation Manchester to bring you this scheme. Today's session on IP, knowing when and why to protect, is hosted by our expert colleagues at Manchester Innovation Factory, Head of IP, Freddy Guemeni, and Senior Manager for Life Sciences, Kathryn Horner. Freddy and Kat will be introducing you to some of the different types of IP you might find in research, with some pointers on best practice and worst practice. Just before I hand over, can I please remind you that this is an interactive training session, so we're going to be asking for your contribution today. I hope you've all got your thinking caps on. We'll be using some polls and breakout rooms to keep you on your toes and make sure you're listening. And remember, this is a learning session, so please don't be afraid to ask any questions. Use the chat function or raise your virtual hand. Finally, a bit of session etiquette. While we're in the main session, please stay on mute unless you're speaking. And in the breakout rooms, we really encourage you to put on your camera if you have one. It just helps everyone to be able to interact and get to know each other. Okay, so without further ado, I'll hand over to you, Freddy.
Thanks for the introduction, Colette. I'm Freddy Guemeni. I'm the head of IP of the Manchester Innovation Factory, so it's the TTO of the University of Manchester. So at the Innovation Factory, what we do, we commercialize the innovation stemming out of the university in order to generate societal and economic impact. So today we're going to talk about what IP is and the different types of rights related to intellectual property. And I think we'll start straight away to make it interactive. As Colette mentioned, it's going to be a very interactive session, so please participate, and that's going to allow you to get the best out of today's session and to make the best use of your valuable time. So first poll, Alessandro, please could you start with the poll here. So the first poll is, I have a question for you. So let's assume that you invent a novel and clever surgical robot that could be used for stopping internal bleeding. You end up applying for a patent, and you have a patent granted that protects your invention, that robot. My question for you, that's going to be a multiple choice question. What right does the patent give you? Having a patent gives you the right to manufacture your robot, and or having a patent gives you the right to stop other people, third parties, from making this robot. So I'm going to reduce it, and we're going to come back to the answers on the following slide. So IP and commercialization. Some of you may have attended the session 3 weeks ago. That was the launch of the training scheme, and you may have heard from my colleague Kathryn Horner about what we do at the Innovation Factory, and also you may have heard from our colleagues at MFT in the trust. So what we work on is about commercializing the IP from the university. But what is intellectual property? I would like to start by saying IP is mainly a legal field. It's a technical field. It's a specialist area of law. And that specialist area, legal area, relates to creation of the mind. Anything that's a produce of the work of your brain, that is dealt illegally as in the field of intellectual property. And any work that you come up with, any ideas you may generate, it may give rise to property right. So in the same way that you would own a house or a car or a bike, you may own the product of your ideas. Another important aspect when it comes to intellectual property is, like similar to any other legal field, is territorial. IP is territorial, which means that if you want to consider protecting the result of your research, or whether you're approached by a third party claiming that you may infringe the IP, the first thing you want to ensure is in which right is the third party claiming, in which territory is it registered, or in which territory could it be enforced. So if you're only carrying out your activities in the UK and you're approached by a US company on the claiming that you may infringe the design or the copyright or the patent, the first thing you want to check is which patent are they talking about? Where is it registered or applied for? If they only have rights, the right protected in the US, and you only carry out activities in the UK, you shouldn't be concerned because IP is territorial. And last but not least, IP as a property right gives you a monopoly right to stop others. So Alessandro, please, now can you close the poll and show us the result? Because this is basically the answer to the first poll, which is what the fact that you have a patent, which right does it give you? And I'm genuinely surprised and positively surprised that we're doing well here. So indeed, having a patent only gives you the right to prevent third parties from manufacturing the robot. Having a patent has nothing to do with your ability yourself to manufacture your product. It's completely irrelevant. So the answer to the first option is false. The patent does not give you a right to manufacture your product. This has to do with freedom to operate. That's another discussion. Your patent is like patent or like any other type of IP right. It's a bit, for those of you who like football, it's a bit like a red card in your pocket that's going to allow you to stop other people from using or from making your creation or your invention. So at the Innovation Factory, what we do, we commercialize the university IP by first identifying what may constitute intellectual property as part of your research, and finally ensuring that the IP is accurately protected with the appropriate IP rights. And today's session is about understanding what are the different types of IP rights. Second poll now, Alessandro, please. And so the second poll is about, you have an idea about a novel and clever way of stopping internal bleeding. You share your idea with few friends at the local pub because you're very excited, right? And a few years later, you realize that one of your friends, of your best friends, sold your concept to a multinational company for £3 million. And we all guess what we want to do, but the question here as the poll, would you be able to share, to claim a revenue share, to ask for a revenue share because it was originally your idea? So the first option, yes, it was originally your idea, so you're entitled to revenue share. And second option, no, because ideas cannot be owned. Interesting. So let's close the poll, Alessandro. So the answer is the second option. Ideas, again, majority of you got it right. And again, I'm positively surprised. That's not always the case. I feel we have an expert audience today. So ideas cannot be owned. As you can see from from the French scholar Henri Debois, who said, ideas are free to be used, and only the realization or the form of expression of your ideas may be subject to ownership. So long story cut short, anyone could come up with the same idea as you, so you cannot claim ownership of an idea. And another aspect when it comes to intellectual property is that it's not a matter of criminal law most of the time. There are very specific cases where it has to deal with criminal law. It's not a matter of criminal law. It means that if you have your IP protected and you feel that a third party is trying to take profit, to benefit from the product of your ideas, from your results, from your exciting ideas, it's on you to assert your rights in front of a judge or by engaging with a lawyer. And it's on you, the burden is on you to prove ownership of your IP. So that's another benefit, that's the main benefit of considering IP protection. Without that, you will struggle to prove ownership of your IP. Another benefit of considering IP protection is, as academics, for some of you, it may increase you may increase your profile by getting more citations. And you see more and more nowadays, people on their CVs not only have the list of their publication, but also the list of patents where they've been recognized as inventors. Further benefits here, from a commercial perspective, protecting your IP gives a hint toward quality to third party, to the external world, to the industry. When potential investors see that you took all the necessary steps to protect your work with IP, it may demonstrate that there may be some value in there. That's why you took all these additional steps. So one additional benefit is that it demonstrates quality to third parties. Another aspect is when you try to commercialize your IP, instead of commercializing just the result of your research per se, having your IP protected allows you on the negotiation table to level the playing field with the big pharma or with the big multinationals out there. And finally, IP protection allow you, having your IP protected could act as an incentive for a commercial partner to invest in your project. Why? Because they know that any outcome of this project could be exclusive to you and potentially to them, and it's going to be a proprietary work, and other people not involved in the project will not be able to benefit from your research automatically, because it will be proprietary. That's what IP allows you to do. And from the point of view of a startup or from an SME, IP is considered, as I said, it gives rise to property rights, and as such is considered as an intangible asset. It can allow you to attract funding and generate collaboration opportunities. It's a business tool to encourage new product development through investment from third parties. It may allow you to secure a market share, mainly because you'll be able, through this negative right, exclusive right, to exclude third parties not authorized by you to enter, to penetrate your market, because you have your IP protected. And finally, as an intangible asset, it can be sold or transferred separately. To sell your IP, you don't have to sell your company. You can sell your IP separately, and it may allow you to generate some revenue like that. And coming back to the principle of IP give rise to intangible assets, if you look at the old-style economy in the 60s or 70s, in average company, most assets of an average company were made of tangible assets, facilities, equipment, warehouse, etc., etc. And that was 90% of the asset of a company. It was made of tangible asset. In nowadays economy, most companies' assets are made of intangible assets in the proportion of exactly the opposite. 90% of assets of a company are intangible assets in the knowledge economy that we're in. Now, sometimes there's a misconception in the mind of researchers that considering IP protection will delay things, it will act as a blocker, because we are used to the research cycle here on the left that is about getting some funding, carrying out some excellent research, and then publishing. That's what we are all about, right? And IP protection is not a blocker, and in fact, it can act as a booster for your research, mainly because by adding that additional step, which is considering IP protection, not only is not going to delay or cancel or prevent you from publishing your result, but in fact, you'll have the opportunity now to generate some impact. And that impact through licensing or spin-out that I think Kat covered a few weeks ago, that impact that you generate have the potential to facilitate your activities of getting more funding to do more research and to getting more publication out there.
Freddy, I think we have a question. If you want to speak to a company about a collaboration, should you go and speak to the Manchester Innovation Factory or a tech transfer office first?
it depends on your status. If you work within in Manchester Foundation Trust or Manchester University Foundation Trust or the university, you should speak to your tech transfer organization. At any step of the process, they'll be my colleagues on both sides will be able to support you, and even if not able to support you directly, we could act as we could do excellent signposting toward other departments of the university who could also support you effectively.
Certainly, and at the University of Manchester, we also have a business engagement team who sort of support collaborations with companies as well. So the University of Manchester Innovation Factory gets involved when there's intellectual property on the table. This might be different with other organisations. So as Freddy said, the first port of call is always going to your technology transfer office is always a really good first port of call, and they'll be able to signpost you to the correct people who you should be talking to, depending on what you need.
Now, sometimes it's unclear for originators, for researchers, where do they fit in the picture of commercialization? So here, we're going to try to clarify that. So as researchers, you generate excellent results because you're carrying out excellent research. And the first role that you're going to have is once you come up with exciting results that may give rise to intellectual property, you'll be considered as the originator of these results. And so depending if you're talking depending on the types of IP that we're talking about, you'll be considered either a creator when you think about copyright, or as an inventor if you think about something more technical like a patent. In any case, who is the creator or an inventor within a project is anyone who makes an original or inventive contribution to the work or to the results. It's not necessarily the people who carries out the work, because when it comes to patent, for instance, it's about the people who came up with inventive contribution, who solved the problem, who gave rise to that patent when we think about patents. And it may not be identical as the people that are listed as authors on the paper. It could be the same, it could be very different. And it's very important to get the list of the originators right, especially when it comes to patent law.
Freddy, we have another question from Rania. So follow-up question to Colette's original question. What if you are affiliated with neither organisation, so not Manchester Innovation Factory or not Manchester Foundation Trust, yet you want to collaborate without losing your rights? I can comment on that, or did you want to, Freddy?
Please go ahead, Kathryn.
So I would say that there is support within Greater Manchester to help you if you are, for example, a spin-out company via organisations such as Health Innovation Manchester, Medicines Discovery Catapult if you're involved in medicine, and people like that. In addition, if you are collaborating with a trust or with a university, they will help you put in the necessary documents to be able to form that collaboration without losing any rights to your intellectual property. So it's likely that they will suggest the collaboration agreements, for example, which you can then review. You can get help from a lawyer to help you do that, or you can get advice from people within the Greater Manchester region. Does anybody in the supporting team have any other suggestions of the sort of support in the Greater Manchester region that spin-outs, etc., can receive?
I would say you might want to go and speak to Health Innovation Manchester. That would be my, so that there's the I can send you the details of it, but there's a whole bunch of funding available through Health Innovation Manchester for local companies. Also Alderley Park have a whole team that will support SMEs, and they've got a scheme very similar to this one, but aimed at SMEs who are trying to bring through new IP. So I can send you the details of both of those.
Yeah, okay. So hopefully that's answered your question, Rania. Please do shout if you've if that's not. Good. Okay, so we've got another question from sorry, not another question, a question from Camilla or Millie. What do patents cover? For example, my field is psychology, so I won't be inventing things, but might, for instance, develop a new psychological measure. what or could this be patented? So I think that the question's for you.
Well, if you allow me, Camilla, we'll come back to that with the different types of IP. So we're going to discuss the different types of IP separately, and you will see for each of them. I invite you to consider for each of them if they could apply for potential exciting result that you may have. So we'll come back to that in a few slides.
Perfect. A question from John. I thought hospitals, or a statement, I thought hospitals and the University of Manchester shared IP ownership with the inventor. So essentially, if you work for the University of Manchester, the intellectual property that you develop whilst working there is the property of the University of Manchester. However, when you come to commercialise that intellectual property, you essentially get a split, and this I'll get Ruth to comment on the Manchester Foundation Trust side of this, where the inventors get 70% of the equity, and essentially from the intellectual property, and the university get 30% of the equity. So that's when you, for example, might license your intellectual property to a company, or spin your own company out. And Ruth, did you want to comment from the Manchester Foundation Trust side how that works?
Yes, although I think perhaps it's worth making the point that not everyone from the NHS who's on this call works for MFT.
Yeah.
Looking at the questions, I think that question's come from John New, who works for Salford Royal. So the principles are the same for all of the NHS trusts. Yes, as the employer, the trust will own the IP, but each of the trusts has an IP policy with revenue sharing arrangements. They are all different because there is no prescribed format for how revenue is shared with inventors. So each trust has its own IP policy, and unfortunately in Manchester they're all different. So I won't talk about what the revenue sharing arrangements are for any particular trust, because that might upset some people and please others, but the principles are the same.
Okay, thank you everyone. So should we progress? So, and indeed what as Kat mentioned is who owns the IP you generate as part of your work. In theory you will own it, except in the case where you consider as an employee. If you develop the invention or the work, the exciting results as part of an employment contract, this will determine the status and the status of the IP you came up with. So any invention made during employment by virtue of employment law is normally property of the employer in most countries around the world, in particular in Europe and in the UK. Now, please refer to the IP policy you are subject to, depending on your status. Regarding student inventors, same, please refer to the IP policy of your organization. But according to the IP policy, so in principle, the student will own their own IP because they cannot be considered as employee if they are not considered as employee. However, there are a lot of exceptions to that principle. And so in particular, when the IP has been generated within the facilities of the university using more than incidental use of resources from the university, whether you collaborated with them, with some of the organization staff from MFT, from the trust or from the university, the situation may vary slightly. And so it's also important to consider the rights of funders or sponsors to the research, because some terms may be dictated by the funding agreement. And so they may have some different type of right in terms of ownership or exploitation of future commercialization of the IP. In any case, it's very important to determine the status of the IP quite early in the process, but your TTO or your organization, there will be department in charge of supporting you in that process. You won't be on your own.
So Freddie, we have another question. This is from John again. So Ruth, I think probably best for you to answer if possible. We have some IP developed at Salford Royal and the University of Manchester. Is that, yeah, so that's right, which we patented, and now that patent forms part of the property of a spin out. Does the ownership still stay split as you mentioned?
It will depend on what agreements have been put in place and what the arrangements are. So if nothing has been changed in any agreements, then ownership will stay the same as it was at the beginning. But if it's been, it's possible that it could have been assigned to the spin out, which means ownership will have changed. Or it's possible it could have been licensed to the spin out, in which case the original owner still owns it, and almost certainly the ownership split, if there is an ownership split, will remain the same. But it really is a case-by-case situation. So I'd need to know more.
I think I didn't realise it was actually University of Manchester in that, John. So if you contact myself or Freddy, we could probably actually look into that and actually give you a direct answer about your direct situation. I'll put my email address in the comments. Could ownership be assigned without asking the owners? Freddie?
What's the question again, please?
Could ownership be assigned without asking the owners? Do you mean the inventors? It depends
on the owners. If the owner is let's say in the case of the university, if the IP is owned by the university is free to commercialize the IP in whichever way it wants to. However, is a traditional practice, is the best practice to involve the originators and the inventors in the process, so they are aware of what's happening and they are consulted as part of the commercialization process. But however, it's important to understand that if the trust or if the university is the owner of the IP, the originator or the inventor is an inventor and have some inventor rights, right to be consulted and right to receive some revenue share as per the policy. But the owner will remain the trust, the organization, and so the owner is free to commercialize the IP in any way it finds suitable. So now we're going to dig into the details of the different types of IP rights. That's the main purpose of the session today, is to get out of here with kind of good understanding of, if you have a product of some result in front of you, what type of IP rights could apply to this product, knowing that a single product could be protected with different types of IP. So these are a quick snapshot. There are hundreds and thousands of different types of IP rights, like geographical indication, like Prosecco or Champagne, plant varieties, and etc., etc. These are just the main one and the ones that you're most likely to come across as part of your practice. So in yellow, what you have is our IP rights that are acquired automatically with no registration needed. In amber, you'll have design and trademarks that can be registered, but in the UK in particular, it's possible to have your design and trademark not be registered and still be subject to IP protection. And finally, the last type of IP, patent. The only way to have your invention patented will be to apply for a patent. Nothing is automatic when it comes to patent. There's a very clear process and with a lot of criteria to be met in order to get a patent granted. So now, third poll of the day, Alessandro, please. So these are three statements here, and if possible, could you tell me if you think that Procter & Gamble commercialized Marmite? Do you think the Coca-Cola company makes the juice Tropicana? And finally, another statement, Nutella is owned by Nestle. I see a lot of true. I think that you're trusting me a lot here with my statement. So thank you very much for the trust. And I will see how it's progressing. So now we're going to move to the slide on trademark. So these are several products on the slide that I'm quite confident you're all familiar with: Marmite, Nutella, Greens and Black, Head and Shoulders, and Tropicana. So what do we have? So I think the majority of you considered all of my previous statements were true, and in reality, they were all false. Marmite is commercialized by Unilever. Tropicana is commercialized by PepsiCo. And finally, Nutella is owned by Ferrero, if you're familiar with Ferrero Rocher. So all of the above was false. What was the point of this quick survey? And for once, you did wrong, so you supported what the message I wanted to get across today when it comes to trademarks. The purpose of the trademark is to create a relationship. If you protect your product with a trademark or your service with a trademark, is to create a connection with the consumer, a direct connection, and the trademark will be there to protect that relationship. And third parties you'll be protected against third parties coming around your trademark to create a risk of confusion. And all of that will happen without the consumer knowing who you are behind, who is the company behind a certain trademark. And the relationship can be quite strong, because if you realize that the decision of buying certain product is directed to a certain level of quality, a reputation of taste that you expect of a certain product. Some people will not use anything else than Head and Shoulders. Some people will only want specifically Marmite and not the equivalent. And so you'll see that that relationship can be very strong through the trademark, and you have no idea necessarily what's the company behind the trademark. And that's the purpose of the trademark, is to protect the relationship between you and the average consumer, and to avoid any risk of confusion. So you'll be protected against a risk of confusion. If a third party come with a similar name or word or logo that could generate a risk of confusion in the mind of the consumer, the judge will ask this third party to stop, and to stop using this similar sign. Another poll now. Alessandro, poll number 4. According to you, which one is the most valuable brand in terms of money? So if one of these companies decided to sell the name today, the brand name, and continue operating, but just selling the IP right, which is the trademark, if they were to sell it to you today, which one do you think is the most valuable brand? I think there's a fight between Google and Apple here, but Microsoft trying to catch up. I like commenting football, that's why. So. Perfect. So I think we got a nice snapshot of the poll here. So we're going to stop here. And according to the majority of you, a short majority, Google is the most valuable brand, followed by Apple. And the right answer is Apple. In the ranking that I checked quite recently, Apple is the most valuable brand, followed by Google. So you did well overall. Apple is the most valuable brand here. So next poll. Knowing that Apple is the most valuable brand, what is the value of Apple in terms of trademark, in terms of brand, according to the Forbes ranking? Excellent again. The answer is right. According to Forbes ranking for value of brands, the Apple brand is worth more than $240 billion. So the point of this here is just to show you that IP can be extremely valuable, and not necessarily we seem to think as scientists, as researchers, that the most valuable type of IP is always patent. It's not necessarily true. Any type of IP can be extremely valuable, as you can see in the case of Apple here. Now, coming to trademarks, there are different types of criteria, but the main thing when you try to come up with the name or with the sign, with the logo to protect your own trademark, to protect your service and your product, your offerings, your commercial offering, your trademark cannot be descriptive. Namely, if you're selling fruits, apple, pears, strawberry, you cannot call your company, you cannot choose a name like strawberry or apple, because that will be describing the product or services you are trying to sell. However, if you want to sell or to offer electronic devices, electronic product, Apple is perfectly fine, because it would fulfill the function of the trademark, which is to be distinctive. Distinctive means the sign that you're choosing needs to allow to distinguish your product or service from third parties' product and services. That's the purpose of a trademark. So it's not about choosing a name that's going to to describe exactly your product. It's about something different. And through the use of your trademark, you're going to be able to acquire distinctiveness, and your protection will be stronger against third parties trying to use similar signs.
Freddy, we have a question. So what is the difference between the two small symbols in a circle, R and TM? And it could be found next to a commercial name.
Yes, I will cover that as the last point here, but I could cover it now, in fact. So TM is made to design to to point toward a commercial domination. So when you're using a sign commercially, when you add a TM toward it, is to indicate to third party or to the public that you're making a commercial use of that name. You are trading with this name. In the UK, there's some protection because, as I mentioned before, trademark could be unregistered in the UK and you may have some level of protection. However, the best protection you can have with the trademark is by registering it. And so the R in a circle is there to indicate that your trademark is registered. It's officially registered at the patent, at the trademark office, at the UK IPO, or in any other trademark office. TM is just to indicate that you're making a commercial use of that name. So in the UK, you'll be able to claim unregistered trademark protection. In other countries of the world, unregistered trademark are not recognized. Trademark, interestingly, is what we call a perpetual right in terms of IP, is the only perpetual right, meaning you can have your trademark registered forever. Provided you renew it every 10 years, your trademark could be registered forever. The main requirement to protect it, to be able to register a trademark, you need to be able to capture it graphically using words, logo, or a combination of words and logo. This is the most important aspect when it comes to trademark. So point number 6, Alessandro, please. So I think I anticipated a bit. So if you have, could you protect, my question here is basically, could you protect the smell of your product? If you think about your product here, let's say, which is an inhaler that we're going to talk about in a second in a breakout session, could you protect the smell of your product? And to help you, let's look at the main 2 criteria here, at the slide here. It cannot be descriptive. It needs to allow to distinguish your product or service from third parties' product and services. And most important, you need to be able to capture it graphically. And so the majority here is right. You cannot register the smell of your product because you can, at this stage of the knowledge of science, it's not possible to represent a scent, a fragrance graphically. So as such, it cannot be registered as a trademark. A lot of companies already tried, but it's not being allowed currently. So no, the answer is no. Not possible to register the smell, the scent of your product. So as such, we're going to now have our first breakout room. So we're going to be divided in a certain number of people with a facilitator in breakout rooms. So please, that's going to last 10 minutes. So we plan for an initial icebreaker. So please, could you introduce yourself in these breakout rooms, describe what you do, your role briefly, and tell us what you're expecting from the session today. And the second part of that breakout session, please, could you, the homework for you is this one. Let's assume that you're the one who own this product on the screen here, the Accuhealer inhaler. And you were tasked by coming up with trademarks. You have to register this product, trademarks protecting this product. What would you come up with? What would you want to protect with the trademark when you look at this product? And I think, if possible, 1 or 2 of you will have the opportunity to report back on what your team discussed. So please, could we now get divided in the breakout room?
So I've just got other rooms created now, so I'm just going to open them. So everybody joining the breakout rooms, you should have an invite to join, including the facilitators, and then you'll just go off for, I think it's set for 10 minutes, this first one.
Thank you. So, okay, now who would like to report for the different rooms? I've seen in somewhere, someone mentioned Gareth. Gareth, would you like to report for your group?
Yeah, no problem. So we were looking at the distinguishing features of the Seretide inhaler. So the most obvious thing that first struck us was the color of the device, 2 tones. The next thing was maybe the shape, the finger holes, pretty distinctive. And now how the mechanism works, sliding left to right to puncture the capsule inside. Then the fact that they've put 60 blister packs on the packet, maybe something. The next is the stylization of the dose, 250 micrograms. on the packet and very small on the inhaler is the Allen and Hanbury's logo. Now, it might not be specific to this inhaler, but it's still something that's on it. I don't know how relevant that is. And then the last thing we had was the internal workings of the device, so the mechanism, and whether that was proprietary and protectable or not.
Yep. Gareth, did you consider the mechanism and the dose for trademark? Just to clarify, please.
Yeah, I think we did, but yeah, maybe that's patentable rather than trademark thinking of it, isn't it?
Thank you. So does anyone would like to add to that something that I've not heard yet that is quite obvious when it comes to trademark as well? Thanks, Gareth, please, for your input, for your great input, and I'm going to comment on that in a second. Any comment or any addition to what could be considered as a trademark?
We suggested maybe the text or the fonts used in that central dial and on the package itself.
Okay, perfect. Thank you. So the lines again, and I think Gareth mentioned something along this. So thanks for your contribution. Something that I guess you all considered. I'm not sure if Gareth said is the brand name, the name AccuHaler. Is it something some of you considered?
So we looked at it, and the trademarking bits where we thought that the AccuHaler was the name of it was a trademark. Maybe the shape and the color of it was either to do with trademarking or with a design. Again, we thought the Allen & Hanbury logo should have a trademark, although it didn't have the TM next to it. Yeah. And again, Severtide. Yeah. But we did think that the AccuHaler device itself was the name of their proprietary way of giving the medication.
Okay, perfect. Thanks for your contribution, and thanks for well done noticing the TM next to the AccuHaler. But that's why, in fact, before preparing that session, I went on trademark registers to check, and in fact, Glaxo registered the word AccuHaler as a trademark. So on this one, the brand name could have been considered for trademark. And Gareth mentioned the color, the two tones, and exactly so trying to make your trademark registration specific. So the two tones, if it allows your product to be distinguished. So if you provide distinctiveness to your product compared to third parties inhalers, yes, clearly the color, the shape, the finger hold. So perfect. Thanks, Gareth, again for that. And related to mechanism and dose and all these things, that should be more like how it works. So when something about how something works, that's about trademark and patent, and we'll consider it in a different session. But when it comes to trademark, I think the dose and the mechanism cannot apply. Is only about the distinguishing feature that make it recognizable by the consumer. Think about it as being on the shelf with competing devices, and what will allow the average consumer to recognize the product. And so it's about everything, every visible feature that we mentioned. So the brand name. Someone mentioned packaging, potentially packaging if it's distinguishable, not necessarily in this case here, the brand name, the color, and the shape. So we're going to move on now to the other types of IP, the other type of IP right today, which are copyright, and it's going to start with the 30 seconds of music, hopefully nice music that you're going to enjoy.
Freddy, I don't think we can see your screen. Oh, it's just the music.
Can you not see my screen?
No.
Okay, what happened here? Is it that I need to start?
I think, yeah, you have to start sharing again when we leave the breakouts.
Okay, sorry for that. I'm not.
I was just checking it wasn't just music.
Can you see the screen now?
Yeah.
Sorry for that. Now we know for the next one. So it's about sharing the screen again after the breakout. Yeah. So music now.
Don't think we can hear.
I think I know what's happening. So it's about option, share your screen, share sound. Screen.
There we go. Sounds like we can hear something now.
So now, some of you may be familiar with that song from 1997 made by The Verve. And the story behind it is that the Verve, they came up with that in 1997. It was, I think, top chart, UK singles chart #2 for 3 months. So, and it generated, I think, more than a million singles sold. So it was massive in terms of revenue and money. But the story behind that is that before composing that piece of music, the Verve got authorization from the Rolling Stone in a contract, in an agreement, to sample 5 notes from the last time from 1965. And they had authorization in the contract to sample 5 note portion of the last time. And it looks like after, when they reached the success, and it was just a massive success in the charts, the Rolling Stone producer or lawyers noticed that, in fact, the Verve used more than 5 notes. In fact, they used 8 note segment of the last time. And so that was considered by the Rolling Stone producer as a breach of contract. And as a consequence of that, instead of the 50-50 split that was agreed between the Rolling Stones and the Verve, they negotiated and they came up to a different agreement. So my question to you, Paul 7, Alessandro, please. What percentage do you think? The original split was 50-50, but because of the breach of contract, there's been a discussion between the producer and the Verve. What percentage of the Verve royalty do you think was allocated to the Rolling Stone as a consequence of this breach of contract? Getting there. So I'm going to close the poll because you have a clear trend here. And according to the trend here, 75% of the Verve royalty was allocated to the Rolling Stone. And almost there, but I think the situation was being more difficult than that for the Verve, because 100% of the royalties was allocated to the Rolling Stones. The Verve received 0 in terms of sold albums and sold singles. It was quite tough, but that's what happened when there's a breach of contract, or when you don't necessarily realize that you signed the contract and there are some obligations that are embedded in this contract. So that's the purpose of the legal teams or in organizations, or the commercialization unit in universities, to make sure that we understand obligation related to the agreement that we all sign as part of our everyday job and of our collaboration. So the consequence can be quite dramatic.
Freddy, we just have a question or a comment from John. Is that because they had clever lawyers, or is that the rule?
I think I don't know. I think it's a matter of negotiation, and it's a matter of lawyers. But I wasn't involved in negotiations, so I don't really know what happened there. But I think it was quite tough for the Verve to come up with a massive success. And I think the Verve, Ashcroft, even said that song was the best success from the Rolling Stone in 20 years.
It was also attached to a great film.
So if we progress from here, now in copyright, as I mentioned initially, is a type of IP that's automatic. It's not perpetual. It doesn't last forever, but it's automatic. As soon as you come up with a piece of work, literary or artistic work, that it can give rise to copyright straight away, provided it's original, provided that it embeds kind of original footprint of your personality. That's what the judge will look for in terms of what you consider as copyright. It's automatic. It arises automatically as soon as you've done the work. You captured your idea in a permanent form, then you've got copyright protection. And it lasts for a very, very long time. So it lasts for, in the UK, when it comes to literary work, it lasts for the lifetime of the creator, plus an addition of 70 years. So that's a very long term, but it's still not perpetual as what we consider like trademarks. And again, same breakout room here, same session. And now for the AccuHailer, what do you think could be subject to copyright on this product? Okay, so thanks everyone for taking part in this session. So will anyone like to report on the discussion within the group? So what could be subject to copyright to protect the AccuHailer inhaler. Any
I
volunteer?
can start if that's okay, Freddy.
Please.
Okay, so we looked at the outside of the packaging first, and possibly the only thing that can be copyrighted there is the logo of the supplier of Alan Hanbury's. We just had a very, very quick discussion that it might be the name if it's the new typesetting. And then if we look into the packaging, there's a patient information leaflet. So the setup of that, if it's specifically laid out, if there are any graphical material with that, that would be copyrighted. And then any form of advertisement that comes with the medication. So we talked about flyers, which are handed out to at conferences or at meetings or at patient information meetings, whatever. Also advertisement that goes to the medics, anything that is a TV advert or on a web page. So.
Thank you very much, Kathy. I feel that you covered it all, and it's exactly that the word, anything that could be recognized as original, the judge will decide whether we are right or wrong, but we could claim some copyright there. We could try to claim. And interesting that you consider the logo. Maybe there's something artistic in there, potentially. And something that came up as part of my group, and I didn't plan for that. I was surprised and, in fact, potentially right. The shape of the AccuHailer could be subject to copyright if it's considered artistic, original, potentially again. So yes, the shape, in addition to everything that Kathy nicely described. Thank you very much, Kathy, again to that. And so let's move to, I think I had a question that I wanted to cover. It was about, then how do you register it if it's automatic? Because we said copyright as opposed to trademark or the rest of type of IP, copyright is automatic. So what's the process? Is mainly if you can prove, it's not a matter of you owning the copyright. You will own the copyright automatically, but you need to be able to show. Is it going to be a matter of proof, more than a matter of ownership? You will own it straight away. You don't need to register it, but you have to prove that you owned it at a particular time, potentially by capturing your ideas in the product of the expression of your work in a certain way or shape or form. If you can prove the date with the website, with the safe, with files, with email exchange, and the leaflet when it was produced. And some people will put a copyright sign, the C in a circle on their material to say C in a circle, copyrighted 2017, these type of things. So it's going to be a matter of proof, not a matter of that you need to register it. You own your copyright as soon as you came up with that work for anything literary and artistic.
Freddy, we had a question actually, sort of slightly not completely associated with AccuHailer, but associated with podcasts and sort of copyright situation around those. But I hope you could comment on.
Oh, okay. Is it a question then about podcasts? Was the copyright?
Yeah. Can you copyright a podcast?
No, potentially, but I'm not an expert. When it comes to media, entertainment is quite so specific. It's a specific industry, and copyright is a very complicated thing. This is more for lawyers, specialists, not for someone like me. So I will just refrain from commenting. So, but the main take-out message here is about anything that could be considered original, that bears the original footprint of the creator, could be subject to copyright. That's my main comment here. Apologies if I cannot comment further on podcast or other things.
No problem. So we've just got a couple more questions on the chat. So Kathy has said, would copyright be required if the design has been patented? In the case of the shape of the AccuHailer, we discussed that the product is likely to be patented. Would that cover the design as well, or would we have to register that in addition? Should we start with the first part?
No,
Sorry.
excellent question. So a single product could be subject to different types of IP. So I will always advise, when you're talking about your own product or your own whatever work results, think about IP separately. You think about trademark first, and you consider exactly as we're doing today. What could be trademark? What is distinguishable here? What is distinct compared to similar product? That's trademark, and you close the discussion. You could register this aspect as trademark. Then you move to copyright, and you see what's subject to copyright, and that's completely independent of the other type of IP. It's not because you would have registered something with the design or with the patent that it cannot be subject to copyright. Okay, so it's completely independent consideration. So one doesn't depend on the other. The fact that you designed it or you registered the design, then it's too late to consider copyright. These are completely separate discussions, and your product could be subject to all of these different types of IP. That's why today I took a single example of the AccuHailer to talk about all types of IP. All of these could apply to your product. So the shape could be subject. Currently, we've seen trademark potentially, copyright potentially, and we'll come to design in a second. And yes, why not?
Perfect, thank you. And we've just got a question saying, is the stylizing of the packaging subject to copyright, since the purple-white split is very distinctive?
Distinctive is trademark. Distinctive should not be considered for copyright. It's about originality. So if the two-tone could be subject to originality, yes. But distinctive is about trademark. So let's separate the discussion and the criteria here. Trademark, distinctiveness. Copyright, originality. Design, overall appearance. We're going to move to that. Patent, how something works. So let's not talk about distinctiveness in copyright. It makes it complicated for yourself, in fact. So if one day you have to work, you take my slides and you take each section completely independently and you look at the criteria of, okay, what do I need to get something trademark? What do I need to understand I've got copyright? What do I need to talk about patent? What do I need when it comes to design?
And finally, sorry, Freddie, we have, I think, a comment from Olo, which I think maybe you'll probably cover in a bit. But it's tricky with the colours because reliever inhalers are generally blue and preventers are generally shades of pink to purple. So maybe the exact shade could be patented. Are you covering that later on, or did you want to comment on that?
The exact shade. A patent is about how something works. Shade is nothing to do with the, I guess, how it works. So the shade or the two-tone, we're talking here potentially about copyright and trademark, not necessarily or design, but not patent. Patent is about the function that we're going to cover in a bit.
Okay, fair enough. So Oli's just also commented the colour coding is for patients so they don't get confused which inhaler is which when changed. So that actually could change things a little bit.
Yes, so if he has a technical function, then you could also consider it for patent then, if he has a technical function and if it's technical. But also,
good question. Good statement, Ola.
So now we've seen trademarks and the criteria for applying trademark to your product. We've seen what was copyright, the originality of your ideas, of the expression of your ideas. We're going to move to design before finishing with patent. So when it comes to design, you'll have seen this product here on the slide. And design is about protecting so what you got the product and you say, okay, can I apply a design right to, can I register a design to protect this product? You will have to think only about the visual of your product. Design rights do not protect technical design. It needs to be extremely clear for all of us. Technical design, anything technical is a patent. The visual design, the visual appearance of your product, the overall impression, the character of your product, any feature that contribute to the character of your product, that's design right. You could apply for a design. You could try to register a design. So it's about, for instance, the color of your product, the lines of your product, the edges, the contours of your product, the ornamentation, all of these things, anything that contributes to the visual aspect of your product or of part of your product or of the packaging of your product, that's subject to design rights. Like for instance, when it comes to the iPad that you would have recognized here, what they registered with the design Apple at the time was the very thin edges compared to the Samsung Galaxy at the time, for instance, their main competitor. So it's the thin edges, and another aspect, the round edges here, the round contour that the other tablets at the time didn't have. That was registered by Apple. So anything that contributes to the visual appearance of your product could be subject to a design right registration. And exactly what it says here is the overall appearance, any aspect contributing to the individual character of your product compared to competitors. Yes, that's a design right. Like the shape of the Coca-Cola bottle could be subject to design right. And finally, if you look, Dyson registered the shape and the lines of the vacuum cleaners. And the line at the picture at the bottom here is the competitor Vax on the right versus Dyson on the left. And Dyson sued Vax for infringement of the design. And it was about, again, the overall impression that the court or the judge had to assess. And in that particular case, I think it was in 2011, if I'm not confused. So the judge considered, surprisingly, as whereas some people like us will consider, maybe there's a case of infringement here. Vax may have copied Dyson design. The judge decided the other way. The judge decided that the overall impression, the overall visual appearance of the Dyson cleaner was elegant, smooth, slick. While the VAX on the right, the vacuum cleaner, the overall impression was more industrial and a bit rugged as opposed to the Dyson one. So the overall impression by the judge has been considered different. So in that particular case, VAX has been found innocent. They've not been found guilty of infringement of the design of Dyson.
Freddy, we've got another question from Millie. If a product's design also makes it distinctive, would it be subject to both design rights and a trademark?
Yes, like example, Coca-Cola bottle here. Yes, the answer is yes. That's why I always say we talk about each discussion separately. You could protect the same aspect with different types of IP and you'll be completely fine with it. Copyright, trademark, design. So the Coca-Cola bottle, I suspect, is subject to even potentially copyright as artistic, maybe. Trademark, if it allows the product to be distinguished from third parties' bottles. And finally, design, because the overall impression is different. So the criteria are not the same, but the same product or part of the product could be subject to different types of IP.
So it's really about protecting your invention with a plethora of different intellectual property rights.
Yeah, protecting your product, because invention is only with patent. But yes,
yeah.
Protecting your product or your service with any types of IP you could apply to it. And you need to involve the expert from your TTO, from your commercialization unit, from your legal advisors, or from your patent attorneys or trademark attorneys. They will be able to advise you on these different steps and to come up with a strategy. So now, same here, if we break out to try to think about features that you put in your design registration that could contribute to the overall appearance, the overall impression related to the AccuHailer here. So breakout room 3.
Yep, so I'll just open them now. And just to be aware as well that everyone, if you need the images, Alessandro's put them in the chat if you need to download them. So I'll just open the breakout rooms now. And you should have a invite to join again. So I'm pretty sure everyone's back in now.
Okay, thank you very much, everyone, again, for participating in this breakout session. So in the interest of time, I'm going to cover what we discussed as part of our group, and we could move on to the last type of IP, that's pattern. So in terms of design, again, my strong advice, if you want to concern about your own product or service or whatever offering, you should have a separate meeting for each type of IP. Copyright is a discussion, trademark is another discussion, separate, completely separate, and now design here. Let's not mix up meeting because it makes it complicated, because each of them come with a certain type of eligibility criteria and the way to assess them and the value of them. So putting all of that is IP, but putting them in the same sentence makes it difficult to assess. So now coming to design, it's about any aspect that contributes to the overall impression, to the individual character of your product. Visual, any visual aspect of it. So as part of my group, so my fellows came up with the shape of the AccuHailer, the color, potentially, the two tones, if it's provides different overall impression compared to competing inhalers, the materials, the lines, the texture of the inhaler, and the packaging of the product itself. So the way it's packaged, potentially, yes, if you provide a different overall impression. And someone came up with something that I didn't expect, and that's completely right. The small window here that gives you an idea, I guess, of how much is left in the container. So here, this could be subject of your design. When you come up with the lines and the drawings, you put a small window like that if it provides a different overall impression. So moving on now to
so Freddy, sorry, just to interrupt you as usual, sorry. We had a comment in our group which I thought was quite an interesting comment from Bruce. That sort of said, I'm surrounded by things that have got similar shapes. I've got these 3 guitars on my wall that have got similar shapes. So what's the difference, and what stops somebody from making something that's the same shape or whatnot? So yeah, I hope I've asked that question correctly, Bruce.
So So is it that you register the design and you feel that similar product may have the same shape?
Yeah, so what's the point of registering a design? And also, you know, why is there so many things out there that have the same shape? So what's the point of a design right, I suppose, is probably the question.
Okay, the design right could be as valuable as anything else, as any other type of IP, as you saw with the Dyson. When you invested like £10 million in the R&D project to come up with a great design that will appeal to your customers, that's where you will protect it, because it's valuable, because your competitor will try to benefit from it. But it doesn't, I'm not saying that, I just asked the breakout session purpose is about what could you consider as a design registration. I'm not saying that the IP office will allow you to register it as a design. Also, in the UK, unregistered design are recognized, but for a shorter period, and it's more difficult to enforce. So you could consider an unregistered design protection. But if you want to go toward the route of registration, it's anything that could contribute to the overall impression. So it may not be the shape if others are similar. If other products are similar in terms of shape, you will not register the shape in design. It's anything that provides a different overall impression, different one, not the same. So if it's similar, no, it's not worth it. You will not even be granted. Yeah.
Thank you. And then the second question was, is sort of being first to market, so having that first design first an advantage, or do you have to have registered that that design right to have that advantage?
So there's some criteria that I'm not covered today in terms of design, because I will always advise you to go to an expert, a design attorney, to advise you, or to a patent attorney to say, how do we register the design? Is it eligible, etc. So indeed, similar to patent, a design has to be novel. But novelty in design doesn't mean the same thing as novelty in patent. You may already have commercialized your product and still be able to register a design, depending on the period of time when you start commercialization. You may start commercialization and then register, but always, I will really strongly advise you to always get, before commercializing anything, talk to your lawyer, to your patent attorney, to your trademark attorney, to your design attorney, and they are best placed to advise you in your particular case.
Thanks, Freddy.
Welcome. Thanks for the question. So now moving on to patents. So patent, last but not least, is the 4 types of IP right that we cover today, or the traditional one, and it's about protecting inventions. What are inventions? Is anything technical or functional. It's about protecting how your product works. So what's an invention? An invention could be a product, a chemical composition, or a device, an apparatus. This could be a product. The product may already be known, because your invention will have to be novel in order to be patentable. Your product may already be known, but if you come up with a new method of making your product that has a better yield, or that use less material, and that produce less waste, you could have a patent to protect that particular method of making your product. Finally, your product may already be known, but if you discover a new use, a new application of your product, for instance, you know about a chemical composition, a particular type of oil that's used for cars, for vehicles, as engine lubricants for engines. And then you discover that particular oil could be used as a gel drops in eyes to cure cataract. You could file a patent directed to the use of that oil that's already known for the treatment of cataract. That's completely allowed. So not everything is patentable, different rules according to the countries, but the main criteria for getting a patent, first, it needs to be an invention. And what does it mean? It's on the left here, eligible subject matter, because there are some things that are not considered invention. The list is very long. The patent attorney will be able to advise you if you've got an invention. Like a discovery is not an invention. A mathematical theory is not considered as an invention. A computer programming theory is not an invention. A method to present information or a business method is not an invention in theory. But again, please talk to your patent attorney. Don't just discard your results straight away. Talk to your advisors, and they'll be able to tell you whether something could be done there to claim the valuable result that you have in front of you. The other 2 criteria are novelty and inventive step. Your product or your invention has to be novel, meaning it should not have already been made available to the public. It should not have been published to before the date where you apply for your patent. That's very strict. But it's not just enough to have something that's novel, that doesn't exist already, that's not being disclosed to the public in the past. Your product also has to be, how can I say that, clever. You cannot just have something novel that's just a simple alternative or adaptation of what's already out there. It has to be clever, so it has to be non-obvious. So that's the criteria on the left. So in this particular example, if your product is a pair of slippers with embedded lighting, You may apply for a patent because it's novel, because you know no one came up with that. It's not being disclosed anywhere. So novelty will be granted, recognized by the examiner, patent examiner. However, the patent examiner could be able to show that the prior art already had element that could allow the person specialist in your field, the skilled person in the art, to get to your invention. So your invention is not that clever, so your invention is obvious, so your patent will be rejected. Now, coming back to the novelty aspect, because we work in an academic context, we do a lot of research and we publish. Invention must be new. So if you already publish your invention, then you cannot get a patent directed to your invention. It will be considered too late. So it's important to keep things confidential. And then you file a patent, you work with your organization or with a patent attorney to file a patent, then you are free to make any disclosure you want to do. And so it's important to consider confidentiality aspect before disclosing. Now, another poll, Alessandro, on this one, a quick one. So if you submit a paper to a scientific journal and it's going through peer review, does the fact that it's going through peer review and you submit it to the journal, does it count as disclosed to the public? Does this count as a novelty disclosure? Novelty destroying disclosure? Massive right here, so.
Can I ask when this, you're sending it to the journal, if it's already got the patent, I believe you can send it to the journal. But if it's not already received the patent, you destroy it by sending it to the journal.
Okay, so you are in the say yes, you are in the side of yes. Thank you, John, for your contribution. So I'm going to end the polling here. The majority of you consider yes. In fact, the answer nowadays with the number of journals we are working with, LCV, Wiley, etc., is not novelty destroying disclosure. The peer review process is made in confidence, but you're always free to consider the terms of each journal you're working with that you plan to submit. But usually submitting doesn't count as a novelty destroying disclosure, no. But however, if the journal advertises a part, a section, an abstract of your journal online, that will be considered novelty destroying. If it's published on the website or in paper by the journal, that's novelty destroying. But the peer review process, the submission of the manuscript to the journal and the peer review, usually again, is not novelty destroying. Another poll, Alessandro. So you discover a formula of a new drug that could be quite useful nowadays, that could be used to treat COVID-19. And you write it down, that piece of formula, that nice formula, chemical formula of your drug on a piece of paper. You're planning, as me in the morning, rushing school run. You forget it in the school of your child on a table somewhere in the corridor. And you realize your mistake a few hours later. You go back to the school and it's still there in the corridor and you recover the piece of paper. Does it count as a novelty destroying disclosure? Interesting. The majority of you consider no. And I suspect because it's in a school, maybe no one had a look at it. But in reality, if we come back to the criteria here, it doesn't matter if anyone had a look at it. It doesn't matter if the person who had a look at it, like a child, a 3-year-old child, could understand chemistry. It doesn't matter at all because the criteria has been met here. The invention has been made available to the public. So as such, this will count in theory as a novelty destroying disclosure. The matter is more, can anyone prove it that it had happened? But in theory, in principle, that would count as a novelty destroying disclosure because it's been made available to the public. And now I would say last session of the day, it's about what could you consider for patent protection to protect the accuhaler. Another breakout room.
Yeah, so I've just created the rooms now, so everyone should have an invite.
So again, thank you very much for participating. So again, in the interest of time, I will try to cover what we discussed as part of our group. So patent is about anything technical that you'll be able to claim in your patent related to your product, how it works, and the function. So as part of my, in our breakout room, so we discussed potentially the composition of the drug, what is inside, the formulation of the drug. If it's formulated as a powder, the size of the particle, of the droplets, or the spray dispersion, someone mentioned dispersion, that could be subject to a patent, provided obviously all of these things that we're discussing needs to be novel and it needs to be not obvious in view of what already exists. The dosage, if the dosage is different, that's potentially patentable. The drug delivery mechanism, the device itself, how it works, if it's different compared to the prior art, that's patentable. The packaging, if it's refillable, that could be subject to a patent. And someone also again mentioned the window here that indicate, I guess, how much is left. So the indication of how much is left in the container could be the subject of a patent. And so anything technical that contributes to the function, if it's clever, if it's novel, that's patentable, including the design. So I'm going to just quickly cover other aspects. So we covered the main types of IP: patent, trademark, design, copyright. What you should consider, the type of aspect of your product could be subject of all of these different types of IP, but there are also all the type of IP that are not traditional, but that as valuable as a patent or a design, like a know-how or trade secret. Know-how or trade secret is anything that you know, knowledge or skill or information that is confidential and that's commercially valuable. This could be considered as a trade secret. So you don't need to register it because the protection is in the fact that it's secret. If it's not secret anymore, then you have no trade secret. If it's secret confidential, then you have it. So it's about controlling, access to it through confidentiality agreement and putting clauses in your employees' contract toward the confidentiality of what they have access to while they're working with you. So it could be like the Coca-Cola recipe, obviously, with this being kept secret for more than 100 years, or a mouse model, cell line, and all of these things, or the clinical trials data could be considered as trade secret and very valuable. So as part of the licensing negotiation that we have, licensing agreement transaction that we do, we license traditional form of IP, patent and design, but we also license the know-how that's related to these projects. Software is another thing. Software, the code of your software, if you have a software, is protected by copyright, the code of it, because it's literary work. But you could consider patenting your software, provided that it has a technical effect on something, like, for instance, a software that will increase the resolution of your MRI. That could be patentable as a software. But patenting is not always automatic. You need to consider the value of it and how you'll be able to enforce it. And I think we don't have time to cover the poll here. I'm just going to cover it verbally like that. Is you commission a software developer to develop an online platform for your company. You pay that developer, that software developer, to deliver the work, but you've not signed any contract, any agreement. And the question would have been, who owns the copyright to the online platform? The answer is the contractor, because when it comes to copyright, the copyright is owned by the creator. So even though you pay the contractor to develop the platform, the copyright may still be owned by the contractor. So you need to make sure, as part of any agreement with the commissioner and the person that's commissioned, that there's transfer of ownership of IP as part of that contract. And some resources for you here, but I'm going to leave it now to my colleague, Kat, to finish the presentation. So thank you very much for your attention.
So I'll just take myself off mute and oh, sorry, just give me 1 second. There we go. Okay, can everybody see golden rules and case studies? Yes?
Yes.
Brilliant. Yeah, thank you for giving me a little bit of time to talk to you about this. So this is really just to sort of try and bring together everything that Freddy says, as said today, and just give you some top tips and golden rules about what you should be considering when you've got or when you've developed a new invention. We understand that there's quite a lot to take in, especially in terms of intellectual property. The first thing that you should maybe consider, as Freddy mentioned, is if you're going to a conference or preparing a publication, don't put anything on your poster, your abstract, your presentation, or even within your publication that destroys the novelty of your invention before you've published or you've filed that patent application. In regards to publications, also check that you're not going to assign copyright to the publisher. So this can happen in some situations. So it's worth looking at the terms and conditions. So as mentioned, if you do want to disclose this information, it's best practice to ensure that you have a patent filed ahead of doing this. So why is this an issue? And we've got a case study to sort of hammer the point home. This isn't from the University of Manchester, but it is a true story, but we've tried to sort of anonymise it. An academic was planning to file a patent, and this was associated with disease prognosis using proteomic biomarkers. This academic went to a conference and sent information within an abstract that contained essentially novel information that was published online. So it contained the sort of makeup of the biomarkers. So the thing that the technology transfer office was going to, or the inventor was going to patent. So based on this information, the patent attorney advised the inventors and the technology transfer office not to file a patent, and this patent was dropped. So what should the academic have done in this situation? Well, sent their information to the TTO, so whether this was a publication, an abstract, a presentation at a conference, and then they would have looked at this, potentially spoke to the patent attorney, removed anything that was novelty destroying. And I think what we also want to make clear here is filing a patent or not filing a patent, so waiting to filing patent, doesn't mean you can't go to a conference and can't show your discoveries via publication. We understand the need for dissemination of research, and it just means that you need to think a little bit more carefully about sort of what you might be revealing within these situations. So in essence, you shall still go to the ball, but please just do discuss what you're going to say at the ball with your technology transfer office. So you submit a grant proposal after you've made a new invention. Again, just make sure that you've looked at the terms and conditions of the funder. And again, it's likely that they will publish an abstract if you get funded. So just ensure that there's nothing confidential within that abstract. It's worth letting the funders know that there is confidential information within your grant proposal, but I think in general funders perceive grant applications to be confidential these days. Someone shows an interest in your invention, so it could be somebody from industry, so a potential industrial partner, an investor, somebody down the pub. If you want to carry on discussing it with them, get them to sign something called an NDA or a non-disclosure agreement. And this is also known as a CDA or a confidentiality agreement. If you're part of an organisation, they will have a standard one that you can send somebody to sign. And if you are a small to medium-sized enterprise or working at it alone, I'd recommend going onto the Lambert Toolkit, which is an online toolkit that contains lots of different agreements that you can use to collaborate with different parties or put non-disclosure agreements and stuff like that in place. It's probably likely that you wouldn't give the chap at the pub a non-disclosure agreement, but maybe just not discuss your invention with that individual. So obviously, as we've mentioned, a good way of protecting your invention is to actually patent it. But also, as we've discussed, there's lots of other different types of intellectual property protection that you can look at in terms of your invention as a whole. So do consider all aspects. Patents. So we need to, hang on, where are we? There we go. So consider appropriate protection. So I'm slightly ahead on my thing. So we also need to ensure that appropriate due diligence has taken place. And this is it's probably a good idea to look at this at the point of disclosing your invention to a technology transfer office or to whoever you're talking to your lawyer, to anybody. And this is often left too late. So what do we mean in terms of due diligence? Well, what funding have you used to develop this invention? And that's important for two reasons. One, the funder might have consent clauses, so you might require their permission to actually file a patent or to commercialise your invention. And also, they might expect a certain amount of equity, for example, if you want to make a spin-out company based on your invention. So you need to understand the terms associated with that. So You also need to, if you've used any sort of material, so for example, any human tissue or anything like that, ensure that you have appropriate material transfer agreements in place, so that you know that you can appropriately commercialise anything that you've been given to develop your invention, and obviously ensure that you've got any contracts in place with any collaborations with any other different organisations. So that's really sort of a summary of the top tips that we've got in terms of what you should be looking for when you've developed a new invention. In the purpose of time, we did have another case study, but I'm going to leave it and open the floor for questions, because I think that's probably a little bit more important. So that's everything together. If in doubt, speak to a technology transfer office or speak to Health Innovation Manchester. Come and chat to Freddy or I, even if you're not part of the University of Manchester, or Colette or anybody else within the team, Ruth, and we can always signpost you into the right direction, whatever organisation you are from. And thank you for listening, and we'll open the floor for any questions to any of the facilitators. Thanks very much. Okay.
So do we have any questions for Freddy or Kat while we've got them on the line? I'm sure they'd be happy to answer them. You've all been so engaged with this session. Thanks so much.
I think we had a lot of questions throughout the
yeah, we really did.
And yeah, I think it's slightly rushed at the end, so apologies for that. But it's just, I think we just had such a great engagement throughout the session that we thought quicker.
Yeah. Some people have raised their hands. I'm not sure, I cannot see, but some people raise hands.
Yeah, so we've got Bruce and we've got Janet. So Bruce, do you want to go first, and then we'll follow with Janet?
Yeah, sure. I hope this isn't too specific, but I'm always a bit uncertain around repurposing. So what happens if a company holds a composition of matter patent that is still active for a compound, but you come up with a new use or a new indication? How does that work?
So first you will have to think about your own results or your own repurpose formulation in isolation, and see what type of IP applies to it. So one discussion is about what is it protectable by IP? Would you be able to apply a patent, for instance, to that formulation that you came up with, or that new use that you have? And if yes, you are free, you are fine. Independently of, it doesn't really matter the situation of third parties here. It's about, do you have something that's new and inventive? Yes, you will file a patent. Now, another discussion is your ability to exploit your invention, that new use. Then that will come to a discussion called freedom to operate. Are you free to operate? Are you free to commercialize? Then you'll contact your lawyer or your patent attorney, and you'll assess your situation, whether yourself, by using that your invention, are you infringing on third parties' right? But these are two separate discussions. Your ability to protect your IP is one discussion and one situation. Another discussion and project is about your freedom to operate status, and that's legal consideration. I hope I've answered, Bruce.
Yeah, thank you.
Janet, did you have a question?
Yes, my question is just, I'm in the kind of early stages of sort of before almost proof of concept. And when do you decide is the right time to get in touch with the TTO? Is it after proof of concept? Is it more further along the line? When do you make that jump? Thank you.
Excellent question. Timing is so difficult, and a difficult hot topic. So it's about, talk to your TTO if you have a TTO available. Yes, as soon as possible. And we can plan, we can work together to plan. It may not be the right stage to protect anything, but at least it could be a plan. And at least you will have the assessment made by expert, like by project managers like Kat, to work with you about to say, okay, the plan, the strategy will be this. So it's difficult. You may make a mistake by making calls on the decision that is too early or is too late. Just work with your colleagues from the TTO and everything will be fine. It's never a right time. Yeah, Kat?
That's great. And thank you for a great presentation this morning.
I think our overall message, Janet, is it's never too early to engage with us, and any teacher will be the same. We all want to chat, and we're all interested in what you're doing. So please do engage whenever you can.
Thank you.
Okay, so I think we're reaching the end of our time now. I'm sorry if we've not managed to answer everyone's questions, but we are all available for you to come and speak to us at any point. I'd just like to say an absolutely massive thank you to Kat and Freddy for putting so much effort into this presentation. IP can be a bit of a dry subject, but you've managed to add some humour in there, and I certainly had a good time today. Also, we're going to do a very, very quick poll at the end now, because we'd like to know if you want to be part of a Teams group that we're going to set up where we can all do some networking and share some course materials. So if you want to start the poll now.
Yeah, it started.
Okay, great. Thanks, Ali.
So we see this working as a forum for all of us to gather together and discuss things that we were not able to discuss today. And also going forward with the other session, we put the recordings of all the session that we delivered so far. So it'd be great if you want to take part of it.
And also, while the poll's going, say thank you to Colette, Alessandro, and everybody else at Translation Manchester and the BRC for arranging these sessions. It's really, really helpful. So thank you very much all.
Thank you. Big thanks to Jim for organizing all the breakout sessions as well.
Yeah, and Jane as well for keeping it all together. It's no mean feat organising something like this, but I think it's really important. So I really appreciate everyone coming along, being engaged and participating. Okay, I think we can probably end the poll now.
Yep.
Fantastic. So it looks like people will be happy to be part of that Teams group. So we'll set that up, and hopefully then, we can form more of a network amongst the people who've started on the course. We can share some ideas amongst each other. Okay, that was a great session. Thank you, everyone. The next session will be on the 15th of June. It is around team science and building your network. So if you haven't signed up to that, do sign up. We've got some great speakers. We've got Fiona Thistlethwaite from the iMatch programme talking about how you can bring industry partners into your team and make that part of your whole innovation journey. Okay, great. Thanks, everyone. Bye now.
Bye-bye.
Thanks, everyone. Bye.
Bye.